A major legal battle over reproductive rights has reached a pivotal moment, with a federal judge delivering a blow to the Trump administration's policies on contraceptive access. But here's where it gets controversial. The ruling not only challenges the government's stance, but also reignites debates about religious exemptions versus healthcare equity. And this is the part most people miss: how a single court decision can ripple through the lives of millions of women, shaping their access to essential medical care. So what exactly happened, and why does it matter? Let's break it down. Judge Wendy Beetlestone, a prominent figure in the Eastern District of Pennsylvania, has ruled that the Trump-era regulations allowing employers to opt out of contraceptive coverage under the Affordable Care Act were arbitrary and capricious. In a 55-page decision, she criticized the Departments of Health and Human Services, Labor, and Treasury for failing to conduct the required legal analysis and ignoring evidence that contraception is safe and effective. The agency's reversal of prior findings runs counter to the evidence, Beetlestone wrote, effectively voiding the rules in their entirety. The case dates back to 2017. When Pennsylvania and New Jersey sued the Trump administration over its expansion of exemptions. Originally, the Affordable Care Act's contraceptive mandate allowed only narrow religious exemptions for churches. The Trump administration, however, broadened these exemptions to include for-profit and non-profit organizations, citing moral objections. The states argued this would burden publicly funded contraceptive programs by shifting costs to taxpayers. Enter the Little Sisters of the Poor, a Catholic order that intervened as a defendant. They claimed the contraceptive mandate itself was unconstitutional. Beetlestone dismissed their arguments, stating they fall outside the scope of the matter, and noting the nuns couldn't challenge the mandate directly. Mark Rienzi, their lead attorney, vowed to appeal, calling the ruling an out-of-control effort by the states to undermine religious liberty. This isn't the first time the issue has reached the Supreme Court. In 2020, the justices ruled 7-2 that the Trump administration had the authority to create the exemptions. However, Beetlestone's latest decision focuses on the legal reasoning behind those rules. She argued the moral exemption was based on a factor Congress never intended the agencies to consider, and the religious exemption violated the Religious Freedom Restoration Act, RFRA. Congress had rejected a similar amendment to the Affordable Care Act because it wouldn't have subjected religious objections to the judicial scrutiny RFRA requires. So where does this leave us? The ruling could force the Biden administration to revisit these policies, but the legal battle is far from over. Critics of the Trump-era rules argue they prioritized corporate and religious interests over women's health. Supporters, however, see them as a necessary defense of religious freedom. What's your take? Do you believe the government should balance religious exemptions with access to health care, or should such mandates be non-negotiable? Share your thoughts in the comments below. For now, the fight continues. As New Jersey Attorney General Matt Platkin stated, we will keep fighting to protect access to reproductive care. Meanwhile, the Little Sisters of the Poor prepare to appeal, and the nation watches to see how this saga unfolds. One thing is clear. The intersection of healthcare, religion, and law remains as contentious as ever. Health on Flylex. If you found this story compelling, consider supporting independent journalism by donating to the Pennsylvania Capital Star. Your contribution helps ensure accountability and transparency in public policy. https://pn.com/donate/OA-referrer. New Jersey Monitor contributed to this story. Our work is licensed under Creative Commons, CC by NC, ND 4.0. And we welcome republishing with proper attribution. For guidelines, visit https://pencapitalstar.com/republishing guidelines.